take a seat.
All right, ladies and gentlemen, let's get the defendant in, please. My calendar's on the desk. Oh, here it is. All right, ladies and gentlemen, I'm told that the jury has reached a verdict, and before we bring them in, there are additional charges beyond counts 2 and 3, which the jury is assessing the punishment for, that will need to be addressed in a sentencing hearing, and we have proposed a day, I think, of the 29th of September to try to have that sentencing hearing, and I'm told that's not a good day for several of you, is that correct? We have another alternative day. Number one, is the defendant going to insist on the 45-day rule?
No, Your Honor.
I have a bench trial in a criminal matter set here in Dixon County on the 7th and 8th of October. How does that day, one of those days, work for either of you?
The state would ask for continuance in that bench trial because there's a murder trial.
Judge, I have the state versus Kenneth Miles starting October
All right.
4th.
Okay. I have a we have a civil jury trial set for November the 2nd. Is it actually the 1st through the 5th? If it goes, I'm assuming we can do it in an afternoon on one of those days, or any of the days of that week of November available for anyone?
Yes, sir. First and second.
Your Honor, I can do
How about the afternoon of the 2nd? That's election day. We'll do it on the afternoon of the 2nd at 1 o'clock.
Your Honor, I will be in trial that week with Mr. Simmons. The court will allow
That's
me.
fine. We'll allow that. All right, so 1 o'clock on November the 2nd will be our sentencing hearing on the remaining charges. That'll be the only thing, Ms. Lewis, that we need to set that day, since I'm assuming I'll be doing this on a long lunch hour. All right. We're going to order the pre-sentence report to be performed by an officer out of Montgomery County to avoid any sort of conflict with the Dixon County Probation Department that normally would perform that. Now, let me address those of you who are here in the courtroom. I know this is an emotional case. I know that it certainly generates the understandable emotion. As I have said from the beginning, while we have 3 of our members that were the alternates who have had to suffer through everything along with the other 12 but did not participate in the verdict, these 12 people came here willingly to perform their civic duty and, from Knox County, and they're here knowing that they were going to be separated from their family. They have listened attentively. They have given every indication that they are aware of the significance of this case. They have done an admirable job of paying attention as I've watched them. They deserve our respect despite whatever their decision may be. And that means that if you cannot control your emotions, understand that. I only ask that you then, if you know that you're not going to be able to control your emotions and avoid an outburst, that you leave now and watch the proceedings outside. If, on the other hand, you can control yourself, you're more than welcome to remain in the courtroom. So, with that, we will bring the jury in. Mr. Foreman, do I understand that the jury has reached the verdict?
Yes, Your Honor.
If you would please pass your verdict form to the bailiff and let me examine it before we begin announcing it. All right. Mr. Foreman, if you would cooperate, may I hand you back your verdict form and allow you to read this for the record. As to count 2 of the indictment, how does the jury find? Let me just tell you what, it might be simpler to do it this way. Do you find for life in prison, life without parole, or punishment by death?
Punishment by death.
And as to count 3, how does the jury find as well?
Punishment by death.
Have you noted on the form the findings of the aggravating factors that you have found beyond a reasonable doubt?
Yes, Your Honor.
And are they written in on the form itself?
Yes, Your Honor.
All right. And would you read those factors that you find have been established beyond a reasonable doubt?
Yes, Your Honor. The defendant was previously convicted of 1 or more felonies other than the present charge, the statutory elements of which involve the use of violence to a person. Number 2, the murder was especially heinous, atrocious, and cruel. Number 3, the murder was committed for the purpose of avoiding interfering with or preventing a lawful arrest or prosecution. Number 4, the murder was committed against a law enforcement officer who was engaged in performance of official duties, and the defendant knew or reasonably should have known that such victim was a law enforcement officer engaged in the performance of official duties. And number 5, the defendant knowingly mutilated the body of the victim after death.
And does the jury signify that they have found beyond a reasonable doubt that those factors outweigh, those aggravating factors outweigh the mitigating factors?
Yes, Your Honor.
And have all of the jurors signed that form indicating that they unanimously found that to be the case?
Yes, Your Honor.
And as to count 3 of the indictment, without reading the same language, are those the same aggravating factors found for that count?
Exactly the same, Your Honor.
And have all of the jurors signified their unanimous verdict by signing that form?
Yes, Your Honor.
All right, thank you. You may pass that back. All right. May I have just a moment? Ladies and gentlemen, I need to take up one thing. If you'll step back across the hall, please. Our alternates, you can stay where you are. All right, counsel, what's been pointed out to me by Ms. Jones is that in the finding as to the second aggravating factor, the jury found that the murder was especially heinous, atrocious, or cruel. They did not specifically specify the other elements of that aggravating factor, which was that the murder was especially heinous, atrocious, or cruel in that it involved torture or serious physical abuse beyond that necessary to produce death. So one of the ways of solving this would be to have the jury come back out, let me then re-instruct them that they must make a finding as to that particular ground or aggravating factor and find all of the elements of that factor, or else find that it does not have all of the elements, in which case it would not be applicable. But for the record, I think it is correct that we would need to address that as an issue. Resubmit it to them, allow them to make that finding if they so choose. I would propose that if they do make that finding, that they simply add an asterisk to this form at the bottom as to whether or not they do find that to be the factor. There are 4 other factors which they correctly identified all of the elements to. So unless there's some strong objection to it that way or a waiver of anyone, I'm going to bring them back in and instruct them on that point and then go from there. All right, let's bring the jury in. We're going to give them the original. All right, thank you for your cooperation. Let me just explain to you, we do this for a living, and sometimes we don't always know exactly how to cross every T and dot every I, but I want to make sure that you understand one thing. When we gave you the instructions as to the aggravating factors, the instructions that I gave you defined the aggravating factor number 2 as being that the murder was especially, well, let me find it. The murder was especially heinous, atrocious, or cruel in that it involves torture or serious physical abuse beyond that necessary to produce death. In this form that you have submitted, you have found that number 2 applied, and you wrote in that the murder was especially heinous, atrocious, or cruel, but you did not include all of the other elements of that crime. So in order to have that be an aggravating factor in support of your verdict, I must resubmit this to you for you to go back and let you make a determination. You may have intended it to, but you have to make a determination as to whether or not you unanimously found all of the elements of that grounds to be, that factor to be applicable. And if you did, then you must signify, and I would suggest you just add an asterisk to add the additional factors that you found as to that number, that second enhancing factor or aggravating factor. If you did not find unanimously that it was proven, all of the elements were proven beyond a reasonable doubt, then you will need to reweigh the evidence against the other 4 against the mitigating factors to determine whether or not you still are in compliance with that. Everybody understand what I've explained? Yes. Right. So I'm going to ask you then to let me submit the original charge to you along with the 2 verdict forms that you have submitted, and we will await your return.
And since I'm out of lines, an asterisk below.
That will be sufficient.
Thank you, sir.
As long as we have a written indication and all of you acknowledge that that is in fact your intent. So, all right.
And do we all need to initial that, or?
I would say everyone initial that underneath the asterisk, and that would be the simplest way. All right?
Yes, sir.
Thank you. If you'll step back, then we will await your return. We'll take a short recess until they return so that we can be on the record to make sure that this is, ladies and gentlemen, we do everything here trying to make sure that all of this is done correctly, and for that reason, we're erring on the side of caution to make sure that it all is done that way. So we will step back out and allow them to complete their business, and then should not take long, I don't think, so if, we'll be back in court as soon as they're able. So.
All rise. Session. You may be seated.
All right, I'm told the jury is now ready again, so let's bring the jury in. Well, hold on just a second. Let's bring the defendant out. So. All right, now we're ready for the jury. All right, Mr. Foreman, has the jury been able to arrive at an amended verdict on that count two?
Yes, sir,
All
my
right.
apologies.
It's all right. Just if you'll pass that to the bailiff, please. As to count two on both the aggravating factor number two, the form now has included an asterisk in that it did involve torture or serious physical abuse beyond that necessary to produce death, and it contains the initials of all of the 12. Ladies and gentlemen, are those your initials, and does that signify that you are unanimously in agreement with this finding?
Yes,
Yes,
Your
Your
Honor.
Honor.
All right. Thank you, ladies and gentlemen. I appreciate your cooperation. Mr. Wiggins, if you will please stand. First, I'd like to announce that I do concur in both the verdict of first-degree murder and the sentence that has been rendered by the jury. And upon the verdict of the jury finding you, Stephen Joshua Wiggins, to be guilty of murder in the first degree as charged in the indictment, and upon further the verdict of the jury fixing the punishment as death, it is therefore ordered that you shall be put to death by lethal injection in the mode prescribed by law pursuant to the provisions of Tennessee Code Annotated 4023-114. You shall be transferred to the custody of the warden at the State Penitentiary in Nashville pending appellate review. This is the 12th day of August 2021. The defendant may be escorted from the courtroom. For the record, both count 3 and count 2 were so amended and by the signatures and asterisk and the initials of all of the jurors. If I failed to announce that, that was in fact the case. So that the record is clear, is count 3 and count 2 that you've added both the asterisk and your initials, are both of those findings by you unanimously that that factor did, in all of its elements, were found to be an aggravating factor?
Yes, Your Honor.
Thank you. Let me tell you that I can't thank you enough for your time, your attention, and your dedication to this job. I know you didn't ask for this. I know you've come a long way from home to do it. You've been away from your families and your friends and been isolated along with each other. I appreciate everything that you've sacrificed to be here to do that. I know that the family of Mr. Baker appreciates that as well. And I thank you for your time and everything that you've given up to be here today, and want you to know that we as the citizens of Dickson County. So with that, you are discharged from the jury service, and we'll arrange to transport you if you'd like to go back to the jury room until we can arrange that. And our 3 ostracized members can join you in that jury room if they'd like to. So. And you can now discuss that among yourselves along with however you wish to. So, go ahead. I'll say one other thing for the record. It is not easy to try a case like this from a judge's position. It's also not easy to try it from a lawyer's position. These lawyers have, on both sides, have worked hard to represent their respective interests. Counsel were appointed to represent Mr. Wiggins, and I would appreciate if people would understand that they are doing the job that they were sworn to do. I have sat in their shoes many times in the past, and I appreciate them and the effort that they've put forth. And as for the state, certainly I understand your position, and I would tell you all that I think you've done a very good job in representing your respective interests, and congratulate those of you who feel that you have won this verdict, and understand those of you who feel like it is the wrong verdict. But I believe that justice has been served. So with that, we will adjourn court. Thank you.
Since I have a note from one of the jurors, do you give me permission to do that?
we'll do that. Let me see counsel, please.
He's off the record, Judge.
Off the record.